Most people think estate planning is simple. You either write a will or you don't. And if you want something more advanced, you hear about trusts. But in reality, most people don't actually understand what separates a will from a trust, or why that difference becomes so important when real families are dealing with real situations. The confusion usually starts because both documents are talked about in the same conversation. They are often grouped together as if they are interchangeable tools, but they are not. And treating them as if they serve the same purpose is one of the most common misunderstandings in estate planning. Because estate planning is not just about deciding who receives your assets. It is about how those assets are managed, how they are transferred, and how that entire process unfolds when you are no longer there to guide it. That how is where everything changes. It determines whether your family experiences delays or smooth transitions, whether your estate becomes a private process or a public court procedure, and whether decisions are made quickly or are held up in legal systems that take time to resolve. A will and a trust both exist inside that system, but they operate in very different ways. They are built on different structures, they activate at different times, and they produce very different outcomes for the people you leave behind. A will is often the first thing people think of when they hear the term estate planning. It is relatively simple to create, easy to understand at a surface level, and it allows you to clearly state who should receive your assets after your death. But what many people do not realize is that a will does not actually transfer assets immediately. Instead, it becomes part of a legal process called probate, where the court validates the document, reviews the estate, and supervises how everything is distributed. This process is necessary, but it can take time, sometimes months, sometimes longer depending on complexity, documentation, and legal requirements. During that time, your assets are not immediately accessible in the way many people assume they are. Everything must move through the court system before distribution is finalized. A trust works differently. Instead of waiting until after death for instructions to take effect, a trust is designed to manage assets during your lifetime and after. It places assets under the control of a trustee who manages them according to instructions that you set in advance. One of the key advantages of this structure is that it can often allow assets to transfer outside of probate. That means the process can be more private, more direct, and in many cases significantly faster. It also allows for continuity of control, which means if you become unable to manage your affairs, the trust can already define how those responsibilities are handled without court intervention. So when people ask which one is better, a will or a trust, that is actually the wrong question. The real question is what kind of control, speed, and privacy you want your family to experience when the time comes. Because both tools can exist together, and in many cases they do. A will covers the basic structure of wishes and guardianship. A trust handles more detailed asset management and transfer efficiency. And once you understand that distinction clearly, estate planning stops feeling like a legal mystery. It becomes a system, a structure, and a set of decisions that are much easier to understand and manage. Now that this foundation is clear, we can look more closely at how each one functions individually, starting with the will. A will is one of the most commonly used estate planning documents, and most people are familiar with the idea of it, even if they do not fully understand how it works in practice. At its core, a will is a legal document that outlines how you want your assets to be distributed after your death. It allows you to specify who receives your property, money, and personal belongings. It can also be used to name guardians for minor children and to express final wishes regarding your estate. On the surface, This makes a will feel complete and sufficient for most families. But the key detail that many people overlook is not what a will includes, but how it is actually carried out. A will does not operate immediately upon death in the way many people assume. Instead, it must go through a legal process known as probate. Probate is the court-supervised process where a will is validated, debts are reviewed, and the distribution of assets is officially approved. This means that even if your wishes are clearly written in a will, they are not automatically executed without court involvement. The probate process exists to ensure legality and fairness, but it also introduces time, structure, and procedural steps that can delay access to assets. In some cases, this process can take months. In more complex estates, it can take longer depending on documentation, disputes, or court workload. During this time, assets are typically not distributed freely to beneficiaries. Instead, they remain under legal supervision until the process is completed. This is one of the key differences between expectation and reality when it comes to wills. Many families assume that once a will exists, everything transfers smoothly and quickly. But in practice, the legal system plays an active role in managing that transition. This is not a flaw in the system, but it is an important factor to understand when planning. Because the role of a will is not to bypass legal processes, but to provide direction within them. It tells the court and the executor what your intentions were and how your estate should be handled according to those intentions. That is why a will is considered a foundational document in estate planning, but not always a complete solution on its own. It provides structure, clarity, and legal instruction, but it does not control the timing or method of distribution outside of probate. Understanding this distinction is important because it shapes how you think about the next step in estate planning, which involves tools that operate differently. And that brings us to the next part of this discussion, where we look at how trusts function and why they are often used alongside wills to create a more complete plan. A trust is often described as a more advanced estate planning tool, but in reality, the concept is simpler than most people think once it is broken down clearly. At its core, a trust is a legal arrangement where assets are placed under the control of a person or institution known as a trustee, who manages those assets on behalf of one or more beneficiaries. Unlike a will, which primarily becomes active after death, a trust can be structured to operate during your lifetime as well as after. This difference in timing is one of the key reasons trusts are often used in estate planning. Because instead of waiting for a legal process to begin after death, a trust is already in place with instructions and management rules defined in advance. One of the most important advantages of a trust is that it can help assets pass outside of probate in many situations. This means the legal court process that typically applies to wills may not be required for those specific assets held within the trust. As a result, the transfer of assets can often be more direct, more private, and in many cases faster for the beneficiaries involved. Privacy is another key factor. Unlike wills, which generally become part of the public record during probate, trusts can remain private, meaning the details of asset distribution are not automatically exposed through court proceedings. This distinction matters for families who prefer a more discreet and controlled transfer process. A trust also introduces continuity of control. In situations where the person who created the trust becomes unable to manage their own affairs due to illness or incapacity, the trust can already define how assets should continue to be managed without requiring court intervention. This allows for a smoother transition of responsibility because the framework is already established in advance. However, it is important to understand that a trust is not automatically better than a will. It is simply different in structure and purpose. Trusts typically require more planning, more setup, and ongoing management compared to a basic will. They are used when families want more control over timing, privacy, and how assets are handled both during life and after death. In many real-world estate plans, trusts and wills are not competing tools. They are complementary. A trust may handle specific assets, while a will covers anything not included in the trust and provides additional instructions such as guardianship or final wishes. Understanding this relationship is essential because it shifts the question from choosing one over the other to understanding how both work together as part of a complete estate planning system. And once both tools are understood individually, the next step is to compare them directly and see how they differ in real-world application. At this point, the difference between a will and a trust is no longer about definitions. It is about outcomes. Because in real estate planning decisions, people are not choosing between documents. They are choosing between processes, control, and how their family will experience the transfer of assets. A will typically means your estate will go through probate. A trust is often used to reduce or avoid that process for certain assets. A will is simpler to set up, but it relies on the court system after death. A trust requires more planning up front, but it is designed to operate with less court involvement later. This creates a practical decision point. If your priority is simplicity and basic distribution instructions, a will may be enough for your situation. If your priority is reducing delays, increasing privacy, and maintaining more control over how assets are handled, a trust becomes more relevant. In many real cases, the decision is not either-or. It is layered. A will handles what is left outside the trust. A trust handles what needs structured management or faster transfer. So the real question is not which one replaces the other. It is which combination creates the outcome your family actually needs. Once you think in those terms, estate planning stops being about legal categories. It becomes about designing a system that works under real conditions, not theoretical ones. And that is where everything comes together in the final overview. Once you understand how wills and trusts work individually and how they differ in structure, timing, and legal process, the next step is to understand how they actually function in real estate planning situations. Because in practice, most complete estate plans do not rely on just one or the other. They combine both. A will and a trust are not competing tools. They are complementary components within a larger system designed to manage different parts of your estate in different ways. A trust is often used to handle specific assets that require structured management, continuity, or faster transfer outside of probate. A will is used to cover everything else that is not included in the trust, and to provide additional instructions such as guardianship arrangements and final personal wishes. This combination is important because it closes gaps that would exist if only one document was used. If someone only has a trust but no will, there may still be assets outside the trust that require legal direction. If someone only has a will, then all assets may still be subject to probate, depending on how they are structured and owned. So, the goal is not to choose between them. The goal is to make sure they work together in a coordinated way. This is where estate planning shifts from being a document-based process to a system-based process. Instead of thinking in terms of individual legal forms, you begin thinking in terms of how each piece interacts with the others. What happens during your lifetime? What happens during incapacity? And what happens after death? A trust can provide continuity during life and efficiency after death. A will can provide clarity, instructions, and legal direction for anything outside that structure. Together, they create a more complete framework that reduces uncertainty and improves the transition process for your family. But even this combination is not the full picture of estate planning, because there are still other critical components that determine how smoothly everything works when it matters most, such as who has authority to act on your behalf during incapacity, and how medical or financial decisions are handled if you are unable to make them yourself. That is where the next part of this series becomes important. Because once you understand wills and trusts, the next layer is understanding control, authority, and decision-making power during your lifetime. And that is where we continue in the next episode.